5 seconds to go. Start. The submission made on behalf of learned counsels for the appellants that the conferment of power upon the authority under section 50 of PMLA excluding the procedural safeguards would be contrary to the standard of procedure established by law under Article 21 of the Constitution is also thoroughly misconceived. The validity of Section 50 was sought to be challenged in Vijay Madan Lal on the ground of being violative of Article 23 and Article 21 of the Constitution, and the court upholding the validity observed as under. Indeed, subsection 2 of section 50 enables the director, additional director, joint director, deputy director or assistant director to issue summon to any person whose attendance he considers necessary for giving evidence or to produce any records during the course of any investigation or proceeding under this act. We have already highlighted the width of expression proceeding in the earlier part of this judgment and held that it applies to proceeding before the adjudicating authority or the special court as the case may be. Nevertheless, subsection 2 empowers the authorized officials to issue summon to any person. We fail to understood as to how Article 23 would come into play in respect of process of recording statement pursuant to such summon, which is only for the purpose of collecting information or evidence in respect of proceeding under this act. Indeed, the person so summoned is bound to attend in person or through authorized agent and to state truth upon any subject concerning which he is being examined or is expected to make statement and produce documents as may be required by virtue of subsection 3 of section 50 of the 2002 Act. In the context of the 2002 Act, it must be remembered that the summon is issued by the authority under section 50 in connection with the inquiry regarding proceeds of crime which may have been attached and pending adjudication before the adjudicating authority. In respect of such action, the designated officials have been empowered to summon any person for collection of information and evidence to be presented before the adjudicating authority. It is not necessarily for initiating a prosecution against the noticee as such. The power entrusted to the designated officials under this Act, though couched as investigation in a real sense, is to undertake inquiry to ascertain relevant facts to facilitate initiation of or pursuing with an action regarding proceeds of crime if the situation so warrants and for being presented before the adjudicating authority. It is a different matter that the information and evidence so collated during the inquiry made may disclose commission of offence of money laundering and the involvement of the person who has been summoned for making disclosures pursuant to the summons issued by the authority. At this stage, there would be no formal document indicative of likelihood of involvement of such person as an accused of offence of money laundering. If the statement made by him reveals the offence of money laundering or the existence of proceeds of crime, that becomes actionable under the Act itself. To put it differently, at the stage of recording of statement for the purpose of inquiring into the relevant facts in connection with the property being proceeds of crime is, in that sense, not an investigation for prosecution as such, and in any case, there would be no formal accusation against the noticee. Such summons can be issued even to witnesses in the inquiry so conducted by the authorized officials. Stop.